Stephanie Dobson is back with us this week. Stephanie is a lawyer, mediator, and online educator with Hankin Divorce Law and Mediation offices in Lloydminster and Edmonton. Stephanie, thanks for joining us once again.
Thanks. Nice to be here, Stacey.
Well, we always have so many different things to talk about involving separation and divorce, and it just shows how complicated this actual process is. So, this week it's something we've never discussed before, and that is estate planning revolving around separation and divorce. So, the first question is, what happens to a will after the separation and divorce process?
That's a really good starting point, Stacey. So in both Alberta and Saskatchewan, the separation itself doesn't do anything particular to your will, but divorce is another story. So in Alberta, we look for guidance to the Wills and Succession Act, and in Saskatchewan, we look for guidance from the Wills Act. So unless you wanted to go and have a look at those pieces of legislation, we'll talk a little bit about them here. So if you get divorced, any provisions in your will that benefit your former spouse are automatically revoked. So that means you get divorced and your will automatically cuts out your former spouse from your will. So this means that they will no longer inherit anything from your estate as you've outlined in your will. So if you leave everything to your spouse, they will inherit nothing. However, the other provisions regarding your children or other beneficiaries remain intact unless specifically altered. So it's really a good idea to get your will changed right as soon as you've got divorced. As well, the other piece to that puzzle is your executor, naming of your executor. So if you do name your former spouse, that former spouse will be passed over and the alternate executor will be used as your executor for your estate.
So, what considerations should be given to children when you have to make these changes?
Well, I always encourage families or parents to talk at the negotiation time about nominating someone as a guardian for your children in your wills. So either one of you can make your own provisions in your own will with respect to who is going to have the children if you both should pass away. But it's a really good idea to try to make that be the same person as both mom and dad making their will, because then it gives peace of mind to you. If you are deceased, it would give you peace of mind to know that your children are going to the person that both of you have nominated. The second piece is if you're leaving assets to your minor children, of course, there needs to be a trustee set up to manage those assets.
So, what about beneficiary designations? What happens to that situation, I guess, when you are going through divorce and separation?
Yeah, so unlike your will, the beneficiary designations on things like life insurance policies, retirement assets, RESPs will not be revoked by separation or divorce. So it's really important that as soon as your separation agreement is signed or your court order is entered, it's really important to get those updated. If you're changing your beneficiaries to your children, of course, again, you're going to have to, in minor children, I should say, sorry, you will have to nominate a trustee of the funds until they're of a set age.
Okay, and what about when it comes to medical and financial decision makers with this? I know there is a lot to consider, but those are two very important, areas that need to be dealt with.
Yeah, so usually as part of your estate planning documents, you've got your will, and then you've got your document that helps you with your medical decisions, medical and healthcare decisions. Then you've got your document that helps you with your legal and financial decisions. So for appointing an agent for healthcare decisions, if you become incapacitated in Alberta, it's called a personal directive. And in Saskatchewan, that's called a healthcare directive. And then for appointing an agent for financial and legal decisions, that's called an enduring power of attorney. That's in the event that you become incapacitated. So it's really important to know that these agents are not automatically revoked with separation and divorce. So it's very important that these estate planning documents get updated as soon as possible to make sure that the person that's making these kind of decisions, legal, financial, and healthcare decisions, are the ones that you actually want to be making those decisions for you if you become incapacitated.
Okay, Stephanie, well, thank you once again for chatting with us. Like I said, there's always so many different things to think about when going through this process. So we appreciate you clearing them up for us, and
Yeah,
we'll be back to
absolutely.
chat with you next week.
Yeah, thanks, Stacey.